immigration detain immigrants without giving them a chance at bond? A federal appeals court just hit pause on a controversial ruling, and the decision could change the way immigration law is enforced nationwide. Stay tuned, because what happens next could affect thousands of people facing detention across the U.S. Hello everyone. Welcome back to our channel, Just Immigration News. U.S. Appeals Court halts nationwide rulings on Trump's immigration detention policy. A federal appeals court has temporarily halted a California judge's sweeping nationwide rulings that blocked the Trump administration from detaining individuals in its immigration crackdown without the chance to request release on bond. The three-judge panel of the San Francisco-based Ninth U.S. Circuit Court of Appeals decided late Tuesday to largely pause these rulings while the administration pursues an appeal. The court noted that the California judge likely overstepped by extending class action status to non-citizens nationwide who are subject to mandatory detention. Under the appeals court's decision, the policy ruling remains in effect only within the Central District of California, where the original judge presides. This is another appellate win for the Trump administration, following endorsements of its detention policy by the Fifth and Eighth Circuit Courts. Other courts are still reviewing the issue, with the Department of Justice expecting it could eventually reach the Supreme Court. Matt Adams, attorney for the plaintiffs at the Northwest Immigrant Rights Project, warned that the Ninth Circuit's ruling will leave district courts across the country inundated with habeas petitions, the only remaining route for class members to request bond hearings. The litigation stems from a policy shift by the Department of Homeland Security last year, which classified non-citizens already living in the U.S. as applicants for admission. This designation subjects them to mandatory detention if accused of being in the country illegally, a departure from past administrations, which applied this rule only to border arrivals. The change triggered thousands of habeas lawsuits from migrants claiming wrongful detention without access to bond hearings. While hundreds of judges in individual cases have ruled the policy unlawful, U.S. District Judge Sunshine Sykes in Riverside, California, was the only one to declare it unlawful on a nationwide scale. Appointed by President Joe Biden, Judge Sykes certified a nationwide class in December and in February went further by vacating a Board of Immigration Appeals decision that supported the administration's policy. Sykes acted after the chief immigration judge advised colleagues that they were not bound by her December ruling and could continue following the BIA decision. It's important to note that BIA judges are part of the Department of Justice, not the judiciary. In its ruling, the Ninth Circuit panel said the administration made a strong case that Sykes exceeded her authority, noting that challenges to detention validity should be addressed in habeas proceedings in the appropriate district of confinement. The court also said Sykes likely lacked jurisdiction to vacate the BIA decision, as her December ruling was already under appeal. The panel, Judges M. Margaret McEwen, Daniel Bress, and Carlos B., ruled a day after hearing arguments and after a temporary administrative pause. McEwen was appointed by Democratic President Bill Clinton, while B. and Bress were appointed by Republican presidents. Please remember to like and subscribe so you don't miss future updates. We'll see you in the next video. Until then, take care.